Stopping a tax foreclosure. A tax foreclosure sale is a type of foreclosure that is carried out by the tax agency in the county in which the property is located, due to the owner's failure to pay the property taxes. The tax bill usually has to be seriously delinquent before a foreclosure process is initiated. In this video, we will discuss how to prevent the foreclosure, or how to reverse the foreclosure, and how to get the property back if that is what the owner wants. Remember, if you don't redeem the property, which means pay all the debt and get it back, then it is possible to still get some funds from the sale, if the sale price was higher than the total debt amount. This is called claiming the excess proceeds or excess funds from the sale. See our other videos for more on this. Let us briefly look at the special rights for military families. Active duty military persons have special protections against foreclosure sales, including tax sales. As long as the home is owned and occupied by the service member or the service member's dependents, these special protections will apply. The protections apply even if there is a non-military co-owner on the property title, who is also responsible for the property taxes. Any tax sale regarding a service member must first be approved by a court. The judge in that court can stay a tax foreclosure sale for up to 180 days after the service member's period of active duty ends. A stay simply means to put a stop. This time frame allows the service member a chance to return to normal life and then take care of any outstanding property tax debt. Additionally, for cases where the property owner is in the military and on active duty, the interest charged on the unpaid taxes must not exceed 6% and no penalties can be assessed. If there ends up being a tax sale, the service member can redeem the sale up to 180 days after leaving active duty, regardless of the normal redemption time period in that state. We will discuss redemption a bit more later in this video. Now, let's look at what regular, non-military people can do when facing a tax foreclosure sale. Once a property tax bill is seriously delinquent, the taxing authority will begin a process to sell the land or home, to obtain funds to use to pay the tax debt. In some states, this same process can be used if a homeowner failed to pay water or sewer bills. The best chance to prevent or delay the sale is to act quickly. Your rights vary greatly, depending on whether or not your state requires a court order before the tax sale can take place. Texas state requires a judicial process, which means you must first be sued, and attempts must be made to notify you of the lawsuit, so that you can defend yourself. In Texas, as with the states that require a court process, the tax office attorneys must get a court order, which is called a judgment, and then get an order of sale, permitting the tax office to move forward with the foreclosure. If your state requires a court order to sell the home, you should participate in the court case and raise all available defenses. Were all notice requirements followed? Were all the property owners named in the lawsuit? You will probably need a lawyer to identify possible defenses because these are complex legal and procedural defenses. If your state allows a tax sale without a court order, this means that the taxing authority can proceed with a tax sale just by notifying you, and the sale does not involve a judge. In that case, you will have to file your own lawsuit to stop the tax sale. Unfortunately, there are few grounds for such a lawsuit to stop the sale. Generally, it is too late to challenge the assessed value of the property if you did not raise that objection in a timely manner with the tax office after receiving the tax bill. You will need the help of a lawyer if you are going to try this defense, but it has a very low chance of success, even with the assistance of a lawyer. You could always respond to any notices, and definitely respond in writing whenever there is a lawsuit involved. You could try equitable defenses such as medical illness, personal crises or tragedies, local or national disasters that have set you back financially. Sometimes, the judges will delay the process by sympathizing with you, and this gives you more time to come up with a payment plan and avoid a foreclosure. Generally, once a tax sale has been completed, the former owner can either redeem the property, as described in the next section, or accept the sale and lose the property. A third possibility is to find grounds to go to court to set aside the completed tax sale. Setting aside essentially means to reverse and cancel the sale, as if it had never happened. The tax office will have to return the money collected from the buyer at the foreclosure auction, and then the deed that transferred the property to that buyer will be rescinded or canceled. The court case will then become pending again, until further court orders or further judgment by the judge. The grounds to set aside a tax foreclosure sale are very limited, and you will need a lawyer to investigate why the sale was illegal or done in violation of notice requirements. Was notice improper? Was the tax sale conducted improperly? Were the taxes no longer due? Was there fraud involved? Did the purchaser have the authority to purchase? Did the taxing authority mislead the homeowner? Typically, selling the property for a low price compared to the estimated market value is not enough grounds to set the tax sale aside. In most states, even after the tax sale has been completed, the property owner still has a chance to save the property or home through a process called redemption. Redemption is a right that the former property owner has to get the property back if the former owner acts within a specified amount of days following the foreclosure sale. Former owners have a specified period of time to do this, and this deadline is strictly enforced. So, it is critical that you act within your state's deadline. Often, you have as long as a year to redeem. But time periods vary, and the redemption will be much simpler and often for less money if you act quickly after the tax sale. Here in Texas, former owners, or heirs to deceased former owners, have 2 years to redeem the property back after a tax foreclosure sale. To redeem, you have to pay the entire unpaid taxes, penalties, interest, and the costs and expenses incurred by the purchaser at the tax sale. Typically, someone facing a tax sale does not have the cash to make this large lump sum payment. On the other hand, many homeowners facing a tax sale do not have a mortgage on their home. Usually, if there is a mortgage, the servicer would have paid the property taxes to avoid the sale, and then there would not be a problem of unpaid property taxes. Having a home free of a mortgage may make it possible to borrow the redemption amount by taking out a new mortgage. But beware of scammers. There are unethical people out there who search lists of tax sale properties and contact desperate homeowners with fake deals that are designed to rip the owner off. If your home equity is a lot more than the redemption amount, you should be able to obtain a legitimate mortgage loan and avoid predatory lenders. Shop around for the best deal by starting with your local credit union or bank. Another option is to ask the purchaser at the tax sale if you can pay the redemption amount in installments. But be careful of the terms and get a lawyer involved to help you review all documents before you sign anything. Some speculators purchase homes at tax sales to take advantage of the homeowner's desire to redeem. They offer homeowners fraudulent sale-leaseback schemes or high-rate loans. As a last resort, if all else fails and you must redeem, you can consider filing a Chapter 13 bankruptcy and pay the redemption amount in installments on terms that you propose and that are approved by the bankruptcy trustee and the bankruptcy court. Be sure to contact a bankruptcy attorney to see whether this is a good course of action. Also ask whether you will have 3 or even 5 years to spread out the payment of the redemption amount, or whether the amount must be fully paid before the redemption period expires. Lastly, ask the bankruptcy attorney if there are other advantages to redeeming through a Chapter 13 bankruptcy, considering all of your other debt obligations. Some other options to catch up on the unpaid taxes. Try and get a compromise with the tax office. The taxing authority may have the power to reduce your delinquent taxes or to waive penalties and interest. This relief is not available in most states though. The property owner also often have to pay the compromised amount in one lump sum, which may not be doable for many. Another possibility is to get a deferred payment plan. If you are behind by several property tax payments, you will also owe penalties and interest. Some taxing authorities permit property owners to pay the debt in installments to avoid a tax foreclosure sale. You will have to pay a fixed amount toward your overdue balance while at the same time keeping up with the new tax bills. The payment plan usually suspends further penalties if you stay current on the payment plan, which is very helpful. As a very last resort, if you cannot raise the funds from any other source, and have other debts that you are now unable to pay, then you could consider a Chapter 13 bankruptcy. The mere filing of a bankruptcy will trigger an automatic stay, which prevents any foreclosure from continuing. After the automatic stay is in place, you can set up a plan where you pay the delinquent taxes in installments over 36 months or even as many as 60 months. However, we never recommend this to our clients because it is a very drastic measure, and bankruptcy also significantly damages one's credit worthiness. That concludes our video for today. Remember to always consult with an attorney in your area before taking any legal action regarding your home or real property. This video is for educational purposes only. Thank you for watching.